And I mean, this is not even about vaccines. It's about, I have a medical record for my child who is a minor. I don't want that information crossing through a digital platform to the ministry. The Ministry of Health, even though they don't have the direct ability to start suspending students, they're holding on to that principal's hands, locking them basically, and being able to say, we're not giving you a choice.
In today's report, Toronto-based lawyer Rosie Rumal discusses the implications of vaccine mandates on civil liberties, particularly in the context of education and suspension orders being issued to Ontario school students. She explains the legal frameworks surrounding the Immunization of School Pupils Act, called ISPA, and how the Education Act interacts with it, as well as personal health information laws. I've discussed this at length in previous reports at stopvaccinecoercion.com, including a recent response from Toronto Public Health, which oversees Canada's largest city. So please check out my previous reports for added context if you haven't already. Now, in today's discussion, Rumal emphasizes the importance of individual rights and the potential psychological impact on students facing discrimination and exclusion from their access to a basic human right, a free public education, due to the refusal to submit medical information to public health surveillance systems. We're going to discuss the impact of vaccine mandates on education, understanding the Immunization of School Pupils Act and the Education Act, the legal implications of medical record disclosure, public health versus individual rights, how other provinces approach all of this, and finally, what remedies may be available for parents and students alike. With over 15 years of legal experience from criminal to business to corporate law, Rumal quickly recognized the civil liberties infringement that was the 2021 Justin Trudeau Liberal COVID-19 vaccine mandate imposition, and immediately began assisting with constitutional law, employment law, and human rights litigation, believing that there is no space for an oppressive, tyrannical government within a democracy. So she took action.
I pretty much opened up practice and I started to help individuals who are facing termination due to their vaccine status or lack of ability to disclose their vaccine status. I was helping with employment law matters. I was helping individuals who were protesting mandates, all different types of mandates, people that either organized protest, attended protest. And, I'm very privileged to have represented some high profile cases as well. And I mean, some of them went well, some of them not so well, but there we are, right? It's just a system. And at least I was able to help them go through this process confidently. And I was very lucky. I feel very lucky to have represented them. I also represented a lot of people that attended religious gatherings. So we've all heard about all the different churches that people were attending, religious gatherings. There were restrictions, gathering limits as well. And I was helping those individuals because they all received tickets anywhere from, $800 and $750, $880 tickets upwards. And I was representing them as well. And these are considered like quasi-criminal cases because they are dealt with at the Ontario Court of Justice. I also helped individuals with pretty much all of these types of matters. And there was some small businesses as well that chose to stay open, beside big box stores. And I assisted them as well because they had not only provincial infractions, but bylaw infractions as well. So since that day onward, I have been involved in the freedom movement, and I believe in freedom to make our own decisions and not be coerced by an oppressive government. So here I am, helping away in whatever little capacity I can.
Fast track to today, students in Ontario face suspension threats unless their parents disclose their personal medical information, such as vaccine records or exemptions under the Immunization of School Pupils Act. This data is collected and centralized in a database called Panorama to monitor vaccine compliance, which aligns with a federal $147 million medical surveillance initiative. Many parents oppose this, citing concerns about data breaches and the potential misuse of medical records. They argue that such disclosures violate the Personal Health Information Protection Act, which requires consensual, non-coerced sharing. There's also confusion over jurisdiction, as only principals can suspend students under the Education Act, not ISPA directly, which, as Rosie explains, creates a significant legal gray area.
We have what we like to call a slight slippery slope, but ultimately, No, the ISPA does not grant any MOH officer to suspend a student directly. However, it gives the authority to anybody from the Ministry of Health to order a principal or an individual who controls a type of school to have them force a suspension on a student that has not complied with ISPA. So my understanding of the Education Act is that there is a threshold. So you're looking at a principal owner of a school has the ability to suspend a student anywhere from 1 to 20 days. Suspensions are not more than that. And there is that threshold that has to be followed. So it's at the discretion of the principal how long they can actually suspend a student for. However, that is subject to certain exceptions if another act applies. So in this case, we're looking at ISPA, and it very clearly says in ISPA that if there's an individual who has not complied, then an order could be made for the principal to suspend the student for exactly 20 days. So there's no threshold that's been applied there. There's no line of, on a scale of 1 to 10, it's already been determined in ISPA that anybody who's not compliant will be subject to the maximum 20-day suspension. Now, ISPA allows a Ministry of Health or the Minister of Health to come in almost in a, let's call it an advisory role, to provide some type of information and receive information in the interest of public health. So these ministries are expected to work together, collaborate in the interest of public health. So really, that's pretty much where their authority comes from. I mean, ISPA is a completely separate act. It's a completely separate act from the Education Act as well. And that's where the Ministry of Health comes in. And I would say more of an advisory form. And that's why it's also discretionary. And, it's really up to each separate ministry in each separate region. We all heard about there was a huge blitz in Waterloo early last year, I think it was February 2024, where the region of Waterloo decided to crack down on, these vaccine immunization records. And over 18,000 students were on the verge of being suspended. Who do you have to thank at the end of the day to do something like that? And of course, I'm being sarcastic, but who does this? At the end of the day, it was the Ministry of Health who decide to put down their hard hand and be able to say, look, we don't have any of these records. And everybody's going to have to comply. And what are they doing at the end of the day? The Ministry of Health, even though they don't have the direct ability to start suspending students, they're holding on to that principal's hands, locking them basically, and being able to say, we're not giving you a choice. We're advising that you start suspending students that don't have their records updated, or else. And what is the or else? Or else face a fine, or else face an order from the court to produce those records, and in which case it would be possible that the school would face contempt of court.
Now, if a student is not being suspended under the Education Act, which clearly outlines rules and regulations governing suspensions, then it's really a free-for-all, and the usual checks and balances don't apply, which is textbook overreach, not to mention coercive, discriminatory, and exclusionary.
Somehow they came up with 20 days as the number of days appropriate for a suspension. Now, I also want to add, the Ministry of Health can order a suspension, but ultimately the Education Act steps in. You cannot just suspend a student. 1, you have to provide notice of that suspension. 2, you have to provide an opportunity for the student to reply with reference to that or make comment regarding that suspension. And 3, the parents would have an opportunity to, appeal the finding that a particular type of suspension would be appropriate. So, ultimately, they came up with 20 days because they feel that if somebody's not complying with updating their immunization record, whether it be with an exemption or not, would justify 20 days. And, That's the government's justification.
Miraculously, any supposed safety risk disappears once they comply or complete a suspension. Meanwhile, under the Education Act, this suspension length is typically reserved for the most serious infractions, such as bringing weapons to school or committing assault or drug trafficking.
Any child that's, subject to a type of suspension, depending on how they feel, depending on how the school looks at them. In some cases, some of them feel like they're being ostracized, right? Like they, for whatever case may be. And the worst part is that they're getting the higher limit, right? They're getting the full 20 days. So, some principals try to make things easy, and they're like, they do have to, and this is where the Education Act comes in, where they have to provide alternative education format in those 4 weeks. It's not that the individual is suspended and that's it. There's no access to school. They do have to provide some type of environment for the child. But of course, it goes beyond missing education. It's the social stigma of about the entire school finding out, well, there's that one kid, that got suspended and they didn't do anything, but apparently they're not, they didn't release their medical records, or more often than not, they would say, well, that's the kid that's not vaccinated and they got suspended. So of course there's a social stigma, being challenged in that way by the student body as well. And, for information that should be private, right? There have been a lot of cases, even within employment law realm, where employees have challenged their employers and saying, I don't even have to tell you what my status is or not. You're asking for me to prove to you that I've been vaccinated, or prove to you, or actually apply for some type of exemption with HR, but I'm not going to provide anything to you. And there have been some cases, and many unions have also found across Canada, that any type of vaccine mandate was unconstitutional, and it wasn't appropriate for employers to do that. So in the same sense, why wouldn't that apply to children in a school? Why shouldn't we be able to uphold that same legal basis, where if an employer can't ask you for that information, which employers don't, right? When an employee, an adult above the age of 18, applies for a job, they're not providing any of that information. But suddenly in Ontario, in order for you to access education, they need proof of this.
It's important to note here that only Ontario and New Brunswick require proof of immunization for school attendance, undermining the claim that this is for public health, as the other provinces and territories don't impose such heavy-handed, intrusive requirements to disclose private medical information to attend school. Interestingly, Newfoundland and Labrador had the highest immunization rate in Canada, dating back to 2015, without any mandated disclosure, proving that public health goals can be achieved without these overreaching measures.
How can we all live in the same country, but things are so different province to province? So suddenly you have access to education in one province, but you don't have access to education in another. Ultimately, every parent needs to also take into consideration, when they're having these discussions with the administration at their school, keep in mind the harms that are being done to their children. And if they do feel in any shape or form that they are being discriminated against, there are a variety of avenues for parents to reach out and look into their human rights, into their constitutional rights. And that's why it would be important, to reach out to a lawyer to be able to see what your rights are and what you can actually do about them in terms of your legal remedies. When it comes to legal remedies, everything is looked upon on a case-by-case basis, but it's also looked upon in terms of what is a legal remedy available to a particular group of people. In this case, we're looking at a large amount of people who do not want their medical history or medical information to be released to the ministry without their consent. And I mean, this is not even about vaccines. It's about, I have a medical record for my child who is a minor, and I don't want that information crossing through a digital platform to the ministry. And ultimately, where does any legal remedy start? I have to say this, you have to speak up as a parent. One, you have to stand up for your child. You have to communicate with the principal. You have to let them know how they feel. You may find in some circumstances that a principal might, decide to advocate on behalf of you to the ministry, or decide on the different ways that they can assist you. Another, the other half of the legal remedy is you have to talk to a lawyer. There are legal remedies available, but a lot of them are a little bit more difficult. I mean, challenging legislation, challenging the constitutionality of legislation, challenging an act that is not consistent with another act, or challenging privacy legislation, medical health information. These are different things that you would have to discuss with a lawyer and be able to bring upon the appropriate action with the appropriate parties. And the only way you can get that done is if you actually sit down and speak to a lawyer. And I would also, if there's other people that are in your boat or other individuals, then you have to even think of doing things collectively and, focus on the harm that's being done, right? It's not just that the government is asking for this or the government is doing this to us. You have to really focus on what is the harm that's being done to you. Are your privacy interests being breached? Is your medical information crossing over, or has it already crossed over to another ministry, or without your consent? So, ultimately, without giving legal advice here on this platform, one, encourage the parent to speak up. In some situations, there is principal works with you, and in other situations, you just have to speak to a lawyer to find out what your rights are and go that direction.
At the end of the day, schools should be for learning, not a battleground over medical surveillance compliance. Parents must stay vigilant, protecting their children and standing up for their autonomy in the education system they fund. With vague legislation and inconsistent provincial laws, there is no clear justification for mandated disclosure and forced surveillance of medical records. It's important to address the growing influence of pharmaceutical interests and data surveillance systems prone to breaches, especially when it affects innocent children's access to essential social services, such as a free education. For Rebel News, I'm Tamara Ugolini. Don't forget to sign the petition and consider supporting this kind of investigative solutions-based journalism at stopvaccinecoercion.com. That's stopvaccinecoercion.com.